Viral video on social media has ignited a heated discussion about the living conditions and privileges afforded to prisoners in South Africa. The footage taken at Goodwood Correctional Services, this is in Cape Town, showing a man boasting about benefits of life behind bars. Joining me now is Makgoti Thobagale, the National Commissioner at Correctional Services. So good evening to you, and thank you very much for your time.
Good evening, Chloe, and also to the viewers at home or out there.
Let's start with the prisoner at Goodwood, boasting about just how soft life is behind bars in South Africa. What has happened to that particular individual right now?
Well, the offender was charged in terms of Section 23 of the Correctional Services Act. It's a section that deals with transgressions or ill-disciplined behavior. Obviously, we had to raid the cell immediately after getting the information where he was housed. We had to raid the cell, retrieve the phone, and the phone was linked to him. And on the basis of that, we then had to charge him in terms of the act. And we also had to review his classification, because when you are admitted to a correctional facility, you are assessed and you are classified. So we have 3 levels of classifications. We have the lower level. It's a minimum level of security, and we have the medium and we have the maximum. Now, this offender was classified medium. So now, because of the behavior, we had to then review and classify the offender as a maximum, and then allocate him accommodation accordingly.
Where is that accommodation? In other words, I guess what South Africans want to know is the kind of punishment that has meted out to him. Yes, what you are saying sounds as if it is very punitive from your end, but it sounds very technical from our side. What is he, or what are the conditions where he is placed right now?
He is placed in what we call single cells, basically meaning that he is not interacting with other offenders because he's not in a communal cell. He's not having, access to, you call them privileges, but according to our own acts and policies, those are standard requirements that are applied to an offender in a correctional setting. So, like visits from the family and, being allowed to access the canteen to buy, things that you want to buy. So he's actually restricted for a particular period. Yeah. And during that period, we then have to take him through behavioral modification programs so that we can attend to his ill discipline.
I want then to link what has happened here, because it illustrates a pattern of behavior, but also it exposes correctional services for the shortcomings. What lessons has correctional services learned from the Thabo Bester prison escape?
What we have learned from the Thabo Bester prison escape is that we have to apply our standard operating procedures to the letter. Now, what that means is, for instance, if you look at the surroundings or the conditions under which the whole thing, evolved. This is an offender who requested to be put in a single cell because he was fearing for his own safety. Now, that's the Thabo Bester story.
Yes.
Okay. But through the investigation report, one of the things that came out is that the request was deposited, it was attended to, but our controller, who was supposed to approve the request, did not approve the request. Okay. So he was moved before the request was approved. Now, the standard operating procedure is very clear in terms of how you should treat that type of a request. To start with, you need to assess whether it is true that this offender is having, security problems wherever the offender is housed. So you have standard operating procedures, but on the other hand, you have well-orchestrated security incidents. And that's another aspect of the Thabo Bester saga, if you like. Now let's go back to the video, the viral video that we started with.
Yes.
If you check, this is an offender that was able to garner more than 5,000 TikTok followers. So it's an offender who uploaded a number of videos. Now it starts to tell you that there was also a breach of security on the side of our own security officials. And that's the reason why, over and above attending to the offender, I, as the National Commissioner, had to also go to the institution and address the whole complement of our members, and sit down with management. And we are finalizing the investigation on the matter. I can tell you right now that those who have been found having transgressed our standard operating procedures or aided this offender to behave the way he behaved will be disciplined.
All right. Commissioner, we're going to take a break, and when we return, I want to focus the attention on the centrality of gadgets inside prison cells, because there is the problem, and it appears to be a very worrying one if what I have read is anything to go by. Let's take a break. When we return, we're going to continue the conversation with the Correctional Services Commissioner. You're watching News at Prime. If you're just joining us, we're in conversation with Makgoti Tobagale. He is the National Commissioner at Correctional Services. Commissioner, let's talk about the use of cell phones or other gadgets inside prison cells. Can you explain to us, just in simple language, how Thabo Bester was able to keep a cell phone and whatever other gadgets that he used, I think it was a laptop, in his prison cell, and presumably this was up until a body was found in his cell that was assumed at first to be him. How did he keep these gadgets with him at all times?
Okay, let's start with the laptop or gadgets that are utilized to study. There are offenders that apply for the utilization of those gadgets, and there are conditions that are attached to that. Okay. Now, in the case of Thabo Bester, he was studying. That's why he had access to the laptop. But now, we give them access to those gadgets during daytime and in our facilities where they actually, go through classes or do their research. Now, him having to utilize that gadget at night in his cell, obviously that was not in line with the policies. So we put that aside. Now let's talk about the cell phones. The cell phones are not allowed, and also other objects that threaten the security of offenders and also officials. Now, we have a perennial problem here with the multi-pronged routes in terms of how these objects find themselves in our correctional facilities. Number one, we have offenders going to court on a daily basis, the remandees. So they go out and they come back. So you need to be very strict in terms of searching them when they go out, searching them when they come back. Sometimes there are lapses there, and the cell phones and other objects, they get into our facilities. Two, offenders have rights to visits or visitations. Those types of objects also make it through their family members, friends, and whoever visits them. Okay. Three, we have a challenge with our facilities where our fences are low or they are not well manned, and some of these are actually thrown over the fences. So that's why we patrol. That's why we have security measures put in place. Now, the fourth one, which is worrying, is a situation where our own members actually bring through the cell phones during the change of shifts, or those objects during the change of shifts. Yeah. So that's what we are militating against. So that's why you have this proliferation.
So if you are to deal decisively then with this, how is the correctional services able to do it, and do it in such a way that you never have an incident like this repeating itself? Because the argument will be the Thabo Bester matter, gadgets inside the prison cell were central to him escaping. The same gadgets could also put the victims of the very same people who are in custody at risk, because they're able to make calls outside for these people to possibly continue to be threatened. So how do you plan to put this to an end?
We're at an advanced stage of procuring a technology that would jam the cell phones or make them useless, basically, even if you have or gadgets that can transmit. But there are regulations. That's why I'm saying we're at an advanced stage, because you do not want to acquire a technology that would also interfere with other frequencies, emergency frequencies, you know, that are supposed to be applicable to a particular locality or location. So I'm saying we're at an advanced stage because now we are, you know, we have made a breakthrough in terms of technology that will only jam within a correctional facility, and then we obviously will have our own frequency that we utilize inside as officials of the Department of Correctional Services. Yeah. But for now, we detect them and we go in, we rate, we search, we take them out. We have examples of members of the community that have joined the offender population because they get arrested on point through our own detection systems when they try to bring this into these objects into our facilities.
What about your own staff? Because you did mention lapses. If we are to be specific, let's talk Goodwood. Has someone been fired or disciplined for the lapses there? Apart from the people that are going through a court case in the Thabo Bester matter, who else has been disciplined relating to the lapses that you mentioned there, that he moved to a cell without having had approval?
Well, remember, Thabo Bester was in a private facility, obviously contracted to the department. Yeah. There's more than 17 employees of G4S that have been disciplined. Others resigned before they could even be disciplined. Okay. Now, on the side of Goodwood, I indicated that we are still busy with an investigation. Once the investigation is concluded, we'll be able to move on to those. Let me just give you an example of what happened this morning. This morning, there was an arrest of 2 officials from our department whom, through our own detection processes, we detected that they were going to bring in drugs into the correctional facility. They were apprehended this morning. So we are able to deal with this before, on the side of crime prevention. Yeah, we're able to deal with this contrabands that are brought into our facilities.
You mentioned G4S. That's the next topic I'd like to explore. Last year, your department served the company with a termination notice, and the understanding is that this matter is before court. What's the update there?
Well, the sitting is in the month of August. Well, we have 2 contestations there. The first contestation is on the installation of temporary management. So basically, G4S wants us out of the facility. They're saying that they can, still do better without us. Our argument is very simple, is that through the work that we have done for over 1 year, 6 months, there are still issues that needs to be resolved. And I do not want to get into those issues now, because
But safe to say that G4S is not managing operations, correctional services is at Mangaung, is it?
We have a temporary manager installed. They still have their own management, but that management is under, the control of a temporary manager from us.
Their contract is due to expire in June 2026. Do you foresee this case dragging out up until the very last day of the contract?
Yeah, well, we certainly do not want that. But, it can happen given the strategy that they want to adopt, but we'll be very clear in our papers when we appear before the court. But also there's a proviso in the contract that 12 months before the expiry of the contract, we are allowed as the department to get into the facility and start the taking over process. So we are not yet at that point, but when we reach that point, we'll then move in and start the process of taking over, because we are very clear we're not going to extend this contract.
Yeah. All right. I'd like then to talk about the last subject matter here, the 2023 remission, special remission process. This was meant to be for a period of about 10 months. So let's start with how many prisoners have been freed from jail as a direct result of the special remission of 2023?
It's around 14,000.
14,000 people.
Yes.
Of that population, are you aware of some who have reoffended in the communities in which they've been released?
Yeah, of that population, we are aware. And those that reoffended are not more than 200.
What have you done with them?
We've brought them back because obviously they have contravened their parole conditions.
What was the sole reason for this special remission? It can't surely have been the prison population. It
is. Even with that remission, as it stands, our overcrowding percentage is at 44%. And the bed capacity we have is 106,000, and we have 153,000 offenders. So we're still, managing that pressure as I'm sitting here talking to you.
As you say, you said there's about 200 of them,
yes,
who reoffended, and they have since been taken back to prison. Was there consultation with the people against whom they victimized? And I'm saying this because on the document, when you announced to the public that they were being released, there is a special mention that people are going to be interviewed or consulted. The victims would be consulted before their release. Was this done?
Yes, it's part of the parole process. Remember the remission process.
The whole 14,000 of them?
Yeah, you remit into, remember we have 243 correctional facilities in the country and 46 management areas. So a correctional facility will have a quota of this 14,000. So you have to go through. And we were not, and you said that it was over a period of 10 months. So you go with categories. The first category was the category of the elderly. And then you go like that with those categories. So you have to manage each case on its own merit. That's why not everybody, it's not a blanket remission. There's a particular criteria that you apply. And
that criteria was that they are non-violent.
Yes.
So those who've reoffended, they've reoffended in what way?
Well, if you were arrested for, stealing an object of, a particular amount, a lower amount, and you committed the same crime or another crime, or, you would then be brought back. The litmus test here is that when you are released on parole, you're still serving your sentence. But in the correctional supervision space, the social reintegration space. So we still monitor you and all that. Some of them were brought back not necessarily for reoffending. Some of them were brought back for not complying with the parole conditions. If one of your conditions is that you must be at home or the place where you reside by 6 o'clock in the evening, and repetitively we find you outside, we bring you back, because now you are already showing the signs that you are going to pose. You are actually a risk to the community.
Well, do you feel the need tonight to apologize to those communities who have now found themselves either in danger or have had their property stolen by people who were released by yourselves, all 200 of them?
Well, let's put it this way. The special remission, as I indicated, or a remission, as I indicated, is an object of the law. So in implementing the law, there are those risks. So if it was an intentional, a deed which was subjective, then one would apologize for that. But here we are implementing the law. Yeah. That's why I want us to understand this in the context of a normal correctional services legal framework. When you are sentenced in the criminal justice system for a particular period, that sentence, when you get into a correctional facility, according to the law, we start to calculate the time that you're going to spend inside a correctional facility and the minimum detention period, the time that you qualify to be on parole. Now, now it means I should be apologizing every day, because even today, there are offenders that qualified to go out on parole. But remember, for you to qualify to go out on parole, you should have gone through rehabilitation programs, you should have gone through correctional programs, and the case management committee should have reviewed your profile. Yeah. You should have behaved in a manner that accords you that privilege to be considered for parole. And in the process of parole, we bring in the victims to make representation. We consult with the victims. In instances where there are conditions for us to refer the parole recommendation to a review, we do that.
All right. We're going to take a break, but the final subject matter I'd like to deal with is the one that you've already prompted. You're watching News at Prime. If you're just joining us, we're concluding a conversation with Makgoti Thobagale, the Commissioner at Correctional Services. Commissioner, I want to conclude the conversation on the parole system, medical parole. Let me start there. You will remember Xolile Mngeni. If you don't remember him, I'm happy to refresh your memory. He was convicted for the murder of Annie Diwane. This was in 2010. He died in the hospital section of the prison in Cape Town. I think he had brain cancer. Then you have people that are politically linked, that are allowed to leave prison under the guise that medically they are dying, and they are still with us to this day. How do you explain that?
Well, the Correctional Services Act makes provision for a medical parole board. Now, that's a board that consists of experts in the medical field. Based on the assessments by our health professionals, offenders also request their own external doctor's assessments. Applications are made to the medical parole board. As you would know, it's an independent board, so it makes recommendations.
But it can also be overruled, as we have learned.
That's why I said it makes recommendations. Now, there are instances where the board all members of the board would agree on a particular recommendation. And there are instances where not all of them would agree. Now, one case in point, you had the lead member of the board who was responsible for the assessment, who then took recommendations to the board. So you had a board that made a recommendation, but you had dissenting views. The National Commissioner then applied his mind and made a decision. Well, we know that this is still subject to legal contestation, so I wouldn't want to get there. But the essence is that the recommendations come from an expert board, a medical parole board. Now, there are some offenders that when the board is still making those considerations, unfortunately, they pass on. Before I became a national commissioner, I was a chief deputy commissioner dealing with incarceration and corrections. I used to receive applications coming from the medical parole board in the form of recommendations, and I would attend to them immediately because the agency here is that at any given point in time, an offender might pass away. Now, what we do not, okay, the department, cannot ignore the fact that you are dealing with someone who's terminally ill, according to the expert information that is presented before you as a department, and you need to make a decision. Looking at it the other way around, if that decision was not made and that offender passed away in the department, still would be exposed to legal challenges.
So safe to say that those who still live with us and yet they were terminally ill when they were released, it's basically their luck.
Well, I wouldn't put it that way. It's a decision that is made on the basis of expert advice.
I'd like to talk about Hilary Gardy's family. Is it still suing your department for 18 million rand in damages?
Yes.
For the public who may not know, the person who has caused this family to sue you is a man named Rasinkuna, who was released from prison in 2019 and had violated his parole conditions for almost 2 years and was subsequently linked to the murder of Hilary Gardy. Your department is as good as gone here if ultimately he is convicted of Hilary Gardy's murder. Do you agree?
Well, I don't know what you mean when you say the department is as good as gone.
Or it's as good as paying out this amount.
This matter is still in court. And we are putting our case forward on how Parolee Nkuna was monitored over that period of 2 years. So it's a matter that is contested in court. And probably I would want to comment after the effect. I would like us to leave it to the courts.
I guess the point I'm making is that are there better ways? Is the Correctional Services Department trying to find better ways of managing parolees whilst they are outside? Because this is a clear danger to society, and now a family has lost someone. Yes, the matter is still in court. He has not been convicted just yet.
Yes, we are finding better ways. And again, we're taking the technological route. We have a project with the CSIR. It's a research project on an ankle monitoring system that would not necessarily need physical monitoring. As it stands, each and every parolee has got a parole officer who monitors that parole periodically, periodically, and there are records to that effect. And I did indicate earlier on that if, as a parolee, you're found to be, not complying with your parole conditions, we bring you back. In instances where we find that a parolee has been contravening those conditions and the parole officer has not been doing his or her job, we take them through the disciplinary hearing. And I have records of our own that we fired because of such security breaches.
Yeah, but these failures, for some community members, it's a little too late because they end up dying. Now that's a tragedy.
It's a risk that the correctional system carries, and it's a risk that we mitigate with the resources that are at our disposal. I just gave you the figures of the offenders we have. Now parolees, there are more than 55,000. Our staff complement total is 37,000. It includes administrative staff. Now you have 153, you add another 50-something thousand, you have more than 200 human beings that needs to be looked after by less than 20,000 security officials, including those that work with parolees.
Makhoti Tobakale, let me thank you very much for your time.